that leads us directly into our next item, which is review of legislation and potential legislation. And we'll give that to Deputy Superintendent Angie Stallings.
Thank you, and I'm just now logging on to the system up there. It'll just take me one moment, but hopefully you've had an opportunity to take a look at agenda item. Are we on 9.2, Chair? 9.2, and I wanted to bring your attention to a couple of documents that hopefully will help you as you're tracking legislation, as well as bring to your attention there are 3 bills that we would especially like to discuss with you today. Because we think there are very important things that will be happening before we'll be meeting next Thursday, and to give you an opportunity to receive an update on the status of those bills, as well as the opportunity to take any action if you'd like. So first, I've got a list of bills that is, I'm sure we will not have time in the next 20 to 30 minutes to cover all of these bills, but the 3 bills that we'd like to discuss with you today are HB 46, HB 132, and HB 175. They're the top 3 on that list. I also wanted to bring to your attention, last Thursday, Vice Chair Cummins asked me if today it would be appropriate for us to identify the sponsors of the pieces of legislation that match the topics or the items that staff have been working on proactively. Today is the day for all those bill files to become public. So you can see in this list which legislators are working on the bills. And just as a point of clarification, sometimes staff has reached out to those legislators, and other times legislators already had bill files open on those topics, or they reached out to us to work on some of those. So as an example, the dual language immersion bill, Senator Stevenson is very active with that program and has always been, and he actually reached out proactively to our staff when the audit occurred and all the background related to the critical languages and program. And others we've reached out to those sponsors. The other thing I wanted to bring to your attention is we do have the tracking sheet uploaded there. If you look in your executive portion of this item, you can see the version of the tracking sheet that is available to staff only, as well as you through SharePoint, which we talked about last Thursday. In there, you'll see there's a column where you might see the word consulted or involved in that column. And if you'll scroll through, you'll see there's not very many, but I wanted to explain to you the difference between consulted and involved. And the reason that column was added actually started last year, when board members kind of wanted to know what kind of involvement staff had on certain bills. If the word says involved, that means that we closely worked with the legislator, if not asked the legislator to open that bill file. So for example, HB 46 or the dual language immersion one, our staff, we worked closely on those bill files, and the legislator often took a lot of recommendations from us. And then consulted simply means the legislator opened the bill file on their own, but then reached out to staff to either clarify administrative issues or ask for some suggestions maybe on different policy options they had given our expertise. So hopefully that helps. When you see involvement, you understand that that's a little bit higher than the consulted.
Okay. Vice Chair Ellis?
Sorry, I am trying to find where you are. I'm looking at this spreadsheet. Are you talking about in SharePoint?
No,
I'm not seeing anywhere that it says.
It's in 2 places. It's in SharePoint. You can see their executive content, only board members and certain staff. Do you see that executive content there, right here?
Okay.
So if you wanted to click on that, the reason why I'm not clicking on it personally is because it's got information that is meant to be internally.
Sorry, it was off the screen below all the bills.
Yes.
I didn't see it. Thank you.
So, but you can also access that very same information through the SharePoint app. So unless you have any questions, I thought I could quickly go over HB 46, HB 132, and HB 175. Are there any questions before I move on to those? HB 46, which is Educator Licensing Modifications. Then we have HB 132, which is, where's my list here? I think it's called Juvenile Justice Modifications. And then HB 175, Oversight Committee Creation. So let's start with HB 46, because there's been a lot of action on this bill since we last met, as well as to refresh your memory, this bill was drafted based on our board's licensing task force and the report they made to the Education Interim Committee last September. The Education Interim Committee adopted it as a committee bill in November. It has now passed the House and is now over to the Senate, and it is awaiting assignment to have a committee hearing. We believe that will likely happen sometime mid next week. Because of some fiscal noting issues that we didn't anticipate or predict back when we discussed this draft bill with the interim committee in November, we are proposing that a substitute be drafted and that it change a couple of these items in order to avoid the fiscal note. So I wanted to bring those to your attention, and I actually highlighted them. And I've also attached, if you look at the bottom of all those bills and board docs, this substitute is also attached there in your backup. The biggest change to this bill is this language on line 292, which talks about, and there are two things that I don't know that we've discussed as staff with you all, the 2020 date, as well as the need for having our system, our cactus system, to be updated in order for us to comply with this new licensing system. So originally, when the first draft of the bill came out, our staff, we were discussing that this could have somewhere between about a $4 and a $10 million fiscal note, because our cactus system is so old and is drafted in a language that apparently most programmers today don't know how to program in. The other unique thing about our systems, and I'm speaking to this very high level because I don't understand the nuances as much as Deputy Superintendent Jones and Jared Felt and others will know. We have about 26 to 28 applications that are all intertwined, meaning they're all kind of written in a web. And if you take one system down or one system crashes, it compromises all of the other systems. And so the short story is we are in dire need, notwithstanding this policy change to the licensing system, we are in dire need of funding to update our systems. And so in order to avoid Senator Milner and Representative Peterson carrying the fact that our systems are antiquated, and then also in an effort not to stop your policy decision as a licensing task force to revamp and revise our licensing system, we are going to put in there to be fully implemented by July 1, 2020, and if technology and funds are available, comma. And we hope as staff that the money is going to be secured through the appropriations process in another manner. What we did not want is for this bill to die because we aren't able to get the fiscal note funded in this bill. If you have questions about that, you know, Deputy Superintendent Jones and others can kind of explain the weird nuance of fiscal notes and how that works. But that is the impact of the substitute, is to get this policy in place, but if for some reason we do not get funds to actually update our system, it wouldn't bind us to a $4 to $10 million cost that we don't have money to actually follow through with. The other change that
Just 1 second,
oh, yeah.
Angie. Board Member Reeby.
Thank you for doing this. This is fantastic that we're updating cactus. As a person who uses cactus, it is ridiculous. With this fiscal note, would we be coupling this with other issues that we are having in other areas, so that if we received all the funding for all, because this cactus issue and this technology issue deal with a myriad of issues, that if we can address all of them, would we get the funding that we needed to make our system more robust and more up to date? Because right now, in my head, this is what I'm thinking, that we're, you know, asking for a percentage here, a percentage here, a percentage here, a percentage here, and then if we get all of them, we'll have 100%. But if we don't, will we be lacking the funding to get that technology up to date?
So what Angie's speaking to is right along the lines of cactus. And so what I was teeing up basically or advising you on is that come Tuesday of next week, that's where you'll start to see our asks or requests for integration of our systems. Whether we just bridge the systems at this level, try to bridge with the LEAs, we're formulating that with the legislature. So to answer your question, yes. However, it's going to take some more further discussion and further analysis than just what we're talking about today. What we're basically focused on today is the cactus piece, but we're not losing sight of all of the other systems on that too. It's just when that will occur is next week and when we start to develop that further with them. That being the integration of systems and at appropriate levels.
So my follow-up is, if we have a piece of this that doesn't get passed, how are we going to make up the difference to create the whole? Does that make sense?
Right. Go ahead.
Well, I think that's part of the reason why we didn't try to attach the fiscal note to just this bill, because this is one piece.
Yeah.
But
Yes.
that we wanted to take the holistic approach and seek a 10 to 20 to 30. It depends. We're still getting the cost estimates. But to actually fix all of those systems so that the 26 to 28 applications can be dealt with at once, not just cactus.
Okay.
So actually, yeah.
Yeah. So speaking to the fiscal note process, right, is now
You've added a percentage to every different bill so that it's when you, okay.
Well, what Natalie has to do, or what our staff has to do, is they have to respond to the first version of a bill, right? And then if there's subsequent updates, then we can do all that too. So it may seem that we're just isolated on the cactus part as in relation to these bills, but that's just the process. It's not a bad process. We do have opportunity later, though, to expand our requests in accordance with the direction the public ed approach to come back to them, with a more holistic approach to that. Now, if we don't receive the funding or all that too, or we propose to use internal funding and all that too, we make sure you know of that. It's just too hard to say that, well, if this, then this at this point, because we still have so much more to develop with all of the other ancillary systems to Cactus, and we're doing so in a
Thank you.
concerted fashion.
Okay. Board Member Belknap?
Oh, well, it's kind of out of order, but on lines 745, 746, you can answer it when you get there, Angie. Why did they take the administrative license away from the superintendent? Why is that not required? Okay, so you can answer it when you get there, but I have to go.
I'd be
Board
happy-
Member Hanson, did you have your
No, it's
light
me.
on? Board Member Lear?
Oh, did you have two?
You go first.
I just want to make sure that, and it seems like you're doing this, but every bill that we participate in, especially those that relate to cactus, because cactus is especially important to me too, that we make it crystal clear to the legislature, we can't do this if we don't get enough money. And all bets are off. And I hope if we get half of it, we can't do it. I hope that, and that may feel like overkill or I'm exaggerating or whatever, but as one board member, I feel very, very strongly that we can't have a half-ass system any further. Sorry.
Board Member Hanson?
I want to fully understand. So if we ask them to do this change, right? So and we don't get the money, what will happen? We just won't be able to change until we get the money? Or the code will not change? It will be the same as it is until we get the money? Is that?
So, okay, so as part of the process, so let me explain that too. As part of the process, in order to anticipate this question, which this question is, did you look internally first to see if you have funding available to do that? That's part of this analysis. That's part of the fiscal
Right.
note
And
analysis.
right now, the fiscal note says 800,000 is all it says, right?
Yes, yeah. Right now it does. And so if there's amendments or changes to the bill, this is why I was trying to explain that process, is Natalie responds or our staff responds as those changes come in, right? And so we always look internally first, and then we calculate and arrive at a figure. So it's hard for me to answer your question about then what happens, right? Because so if we don't get the funding for the legislature, it doesn't necessarily mean that we can't meet the intent of the bill. It just means that, we have to look and see other things and then come back to you and provide, different courses of actions that you can take in order to do that. I really think we are communicating very well with the legislature or, particular legislators about these concerns that you're bringing up today, and that it's all part of the process of saying, well, look, this is the funding we have. This is what it's encumbered for. If this, then this. And that's a day-to-day process that occurs throughout the whole session. And we do really try to represent the integrity of the process always. So for me to sit in front of you today and say, well, if they don't fund it, if they don't give us additional funding, I really couldn't say that would not, or that would, basically not allow us to use Cactus or do it in the manner that, they're proposing as part of the legislation. But at the same time, if I say, we absolutely dig in and we say we need that, then that's not conducive to the process or ensuring that we're addressing all of the different ancillary bills that are occurring at the same time. So I hope that makes sense. I'm not trying to dance my way out of this, but, that's just the process. We have to trust the process. And it does work, so.
Superintendent Dixon?
To coin a phrase from Deputy Jones, he will often remind us that we can do something, we just can't do everything.
Right.
And I think that's true for this system. The more we've learned about how all of these systems are integrated and connected, there are some things that we can do, but we can't create this great system that we envision without additional funding. So we can tweak, but we don't know until we get into it how it affects other systems. So yes to something, no to everything.
Vice Chair Ellis? Sorry.
I understand the funding request and aspect, but I'm wondering if you can explain why, when we're looking just at the licensing structure and the proposed changes, why we were addressing it legislatively versus here in-house.
So related to your question and somewhat related to Board Member Hansen's question, if this bill passes and we get no funding legally, because of the language that's highlighted right there, we're essentially off the hook to have our whole system revamped by 2020. So then if it took us till 2021 or 2022, as funds were available, we could do that. The other what this does legally is it actually removes most of the names of things like level 1, level 2, level 3, administrative supervisory license, letters of authorization, LEA specific or competency-based licenses. Those references are all removed from statute, which means that the board rules would govern regarding licensing. Because our current licensing board rules all have level 1, level 2, level 3, competency-based, all of that, I would anticipate legally we would continue down the course of our current licensing system until we were ready to transition to this three-level or three-type of system. So I wanted to make that clear too, that legally what this bill does is it actually frees up a lot of language from statute and provides the control to you, the State Board of Education. And we would probably continue on course until we were ready to make those changes to Cactus when we had the money and funds. But then I apologize. So Board Member Ellis, I think the other answer to your question is that's the very point of this bill, is to take out the names of specific license like level 1, level 2, level 3, administrative, supervisory, so that the board is the entity that fully controls these issues. And I think that also relates to why Board Member Belknap asked me, why did we take the language out of 745 and 746? It was exactly that. Currently, we do not even have an administrative / supervisory license. It's actually an educator license with a administrative level area of concentration, I think is the title. And also we're getting rid of letters of authorization on line 748. The impact, this language currently as it's written essentially says that a local school board of a local district has the authority to determine the qualifications, licensing or otherwise, of their superintendents. Because although the first two lines say they must have an administrative license, the second three lines say, but if the local school board wants to hire somebody without one of those licenses, that you, the board, shall give that person a letter of authorization notwithstanding. So that's already current law. Superintendents of school districts are not required to be licensed because their boards can hire them and then we provide them a letter of authorization. So the language was taken out because we did not want to preempt your decisions of whether that's going to look like a letter of authorization, whether we're going to even require superintendents to be licensed, whether it's a waiver. And those are all issues that you can determine in the board rule.
Okay, Board Member Hanson?
I just want to express a concern that this is a big deal. I mean, we've worked on these licensing changes for 2 years through the last election, got everybody back up to speed on them, and now we're going to put it off through another election where we're going to have to get everybody back up to speed on them again. It is a big deal to postpone this.
Superintendent Dixon?
So I just want to clarify what you're asking, Board Member Hanson, are mentioning. So I don't think we're not promoting postponing of anything other than just not holding the board's feet to fire to change Cactus immediately to reflect all of these. So the anticipation that you would be able then to approve the rule, the licensing rule, given the changes to statute, because it opens, statute currently ties your hands. So you may choose then to pass the board rules that you've been working on for licensing.
But
that
can
allows
they
us
go
to
into effect? They can
Yeah,
go
the
into
rules could go into
effect,
effect,
but we
yeah.
just don't have the money to update Cactus so that it won't be really doable. I mean, it won't reflect.
Well, I think there's two answers to your question. Number one, in order to program Cactus and actually change all of the titles and restructure the system, Cactus cannot currently withstand that technologically. So you're correct. We have to have the money to support the Cactus rewrite before the policies can be put into place. And I'm wondering if the second question you had was the change from the 2019 to 2020. Was that part of your second question?
If the policies can't be put into place, then that's a problem for me.
Right. But this bill, if we don't get this bill passed, we could have all the money in the world. And because we've got level 1, level 2, level 3, letters of authorization in code, we couldn't do the policy even if we had the money. So this has to
I
happen.
understand that, but that was my first question,
Okay.
right?
Yes.
Is what happens if we don't get the money and this passes?
Am I-
As far as the funding goes to support a passage of this bill, there are alternatives out there right now. It's just part of the process of determining whether, for example, if you recall when we were talking about end-to-end systems and our systems up here, there was a methodology that was used to give us out of the MSP dollars about 4.3 million to do what we're doing now with the grants management system. So that might be a way to do this. As part of the fiscal note process and looking internally, we also have some identified funding that we could use potentially to, if we weren't available to do that, or look at all the other sources of funding that the legislature might provide along this process, is that would be an alternative to this too. So there are funding alternatives. It just goes back to what the superintendent was briefing. Anything is possible, but everything is not. So what we do is we try to make sure that as we're sitting both here with policy and funding, is that, we will say, well, okay, if the bill passes, we still need to find the funding to do that. And that's what we're identifying as part of this process, is what potential pots of money, so to speak, or availability or of available funds that aren't encumbered could potentially support this bill.
Vice Chair Ellis, did you have a comment?
Thank you. I had received an email with some questions about this. One of them was related to the superintendent portion of the bill, and I just want to make sure they're understanding and that I'm understanding where we are. But does this then put the responsibility in our hands of confirming LEA's choices for superintendents, or we're just setting a rule and then they would still have their own autonomy?
Well, currently, our current rules match what this language is, and our practice is such that legally, you could say that superintendents are supposed to have these licensing, but also licenses, but legally, you, the board, if a board requests it, the Jordan School District's local board requests it, you have to give that letter of authorization. So the awkwardness of these lines here is that really it's kind of encompassed in lines 733 and 734. A local school board shall appoint the superintendent on the basis of outstanding qualifications. Unless you all as a board wanted to take a step to in board rule now apply some sort of a licensing standard for superintendents, we have no role in that. If this language is eliminated, now our office doesn't have to be contacted because Jordan School District wants to hire Scott Jones as their superintendent, and Scott Jones doesn't have you don't have an administrative license, right, in education?
Just an army.
But then they don't have to then ask Diana and Travis to give, or the board to give a letter of authorization. Right now, it's just a procedural step that really in some ways means nothing, but I understand. So nothing's really going to change by this. It just removes the language because we didn't know how to amend it. What is the title going to be of the administrative supervisor license? Are we going to have letters of authorization? Right now, the idea is to discontinue letters of authorization.
Board Member Beebe?
This one step is integral to so many other steps. Our technology systems are really out of date. And this has been a huge impediment to making other things move quicker and bring us all together. And so as we have talked about this for over a year now in finance, these systems need to be as up to date as the people we are working with. So I would like that we really try to support updating our equipment, because it is really hard for us to work with our districts if we are not able to because of our technology. So we have talked about this nonstop in finance. Thank you.
Board Member Lear?
Back to the superintendent issue. Though what was in code before was something of a circular process, it did end up with the board, and actually the LEA had to present information that showed that the superintendent was otherwise qualified. But it did result in the superintendent having a license. If the superintendent has no license and misbehaves, he's beyond the authority of the board. And I hope we just all understand that the highest level person in an LEA would be beyond any licensing action by the board.
Can I clarify as well? Any of that can be addressed in board rule, is that correct? Okay, so we could put some base standards in board rule for the superintendent? Is that?
I guess, can I respond?
Board Member Wright had his hand up.
Oh.
I agree with Board Member Lear's concerns. I think at our charter schools especially, we have people serving as administrators that don't have teaching license frequently. I think that's fine, but I share that same concern. One idea is simply say, okay, you don't have a teacher's license, but if you did, you would have lost it or to put these checks on you. And I think we might have the right to do that, and we put it out there at public knowledge. So then, at least if they want to go get another job at another LEA, it's out there that they blew it.
Board Member Lear.
And my point is, now you made me forget my point, Joel. Right. I personally would be uncomfortable voting for a rule where the law says the superintendent doesn't have to have a license. And I would find that contradictory to what the law says.
Can I ask a clarifying question? So the law, if the law is silent on it, does it prohibit anything for us in that regard? Okay. Angie, did you want to
I
answer
just
that?
wanted
Or
to make the recommendation that you right now just recently created the leadership working group, which is going to talk about administrative licenses and these types of issues. And one topic of conversation for that work group could be, what would a license look like for those people that it could be like an LEA-specific administrative license for those charter school administrators and those superintendents, where it is up to the local school board to say that they've determined this person's qualified, but at least then it would be a license that we could track in our system and that we could pull if there was misconduct. So that might be a good topic for that work group.
Board Member Reby?
I was going to say something similar. We could have a part of our cactus, because we are creating it as non-licensed educators, and they'd have to register with the school districts. So this way we would have ability to track our superintendents and our charter school teachers that didn't have a license but were still educators. So there could be a spot in there for non-licensed educators, but to track.
Board Member
I'm
Lee?
sorry to keep speaking, but I want to make the statement for the record that this is not just hypothetical. I recall 2 different superintendents who have had their licenses disciplined. So it does happen, and I think it is something to consider as a role model for the rest of the district personnel who are all subject to that kind of discipline.
Okay. You can continue. Thank you.
The last thing I just wanted to bring to your attention quickly, which is going to eliminate the $800,000 fiscal note, is we originally as staff had recommended that, and I'm trying to scroll up to the types of, here we go, that these certain professions, speech pathologists, audiologists, psychologists, et cetera, that work in our classrooms, currently they have to be licensed by DOPL. And in order to qualify for the educator salary adjustment, which is about a $4,100 increase to whatever your district is providing for your salary, they also have to currently get a license from the board. The original version of this bill made it so that it was or, so they could have a license from DOPL or from the board and qualify. That triggered the $800,000 fiscal note. So this highlighted language now reverts back to essentially what is current statute. It just replaces the Title 53E reference and just says a license issued by the board. But the idea is that this change will now eliminate that $800,000 fiscal note. So that alone, we were surprised how many of these types of people are working in our classrooms and haven't received the board license. What I've been told in practice is that many of these districts negotiate and actually fund the $4,100 for those people from their own money instead of getting the state money for it. So that was new to me.
Board Member Reby?
Which also brings up the issue with our superintendents and our non-licensed teachers. We had no way of tracking these speech pathologists because they didn't have a license in the past. So by doing this, we're creating a safer system for our students.
And may I say something? One way that you could actually make it, I guess, easier for those who are licensed by DOPL is you could create a license similar to what we're talking about for charter school administrators and superintendents, where we have determined that the qualifications are determined by DOPL, but that we're going to give them a board license almost automatically based on the DOPL qualifications, but then they'd have that license for tracking purposes. So that could be something else that we work through with our rules that are coming now.
Carry on.
And that's all I was going to cover for the substitute. And again, I wanted to make you aware that likely this bill and this substitute will be discussed probably sometime next week before you all meet again, and wanted to give you the opportunity, if you wanted to provide feedback or take a motion. And if not, I can move on to the next bill.
Okay, go ahead and move on.
Okay. In the interest of time, because I know I don't, and feel free to cut me off, whenever you're ready. But there are two bills, HB 132 and HB 175, that we were recommending be discussed today. Because HB 175 is going to be heard today at 2 o'clock in government operations, I'll move to that one. And if you would like, we can talk about HB 132 at a future meeting. HB 175 is a bill that creates a new oversight committee, and I apologize, I wanted to grab the actual title of it, but it's the Joint Committee on Government Oversight, which will include 6 House members and 3 senators, so 9 members total. The purpose of the group is to kind of oversee our school districts, and our charter schools would be included, as well as USBA and the High School Activities Association are all explicitly listed in the bill. But essentially, this group would investigate those entities. They'd look at their policies. They'd investigate. You can see here on lines 181 through 196 the core of their duties, but investigate waste, fraud, misconduct, investigate accounting, expenditure and handling of money. Anyway, you can see there all of the different things they'd be investigating. We wanted to bring this to your attention. This bill is going to be in the House Government Operations Committee today at 2 o'clock. And a couple of board members and others asked that we review this bill today.
Board Member Wright.
I'm a bit slow. It's like this independent state authority that's going to investigate waste, fraud, and abuse at our LEAs?
I would say it's not independent. It's a legislative committee. So it's kind of similar to the Administrative Rules Committee that we're subject to right now. You know, whenever we pass a rule, sometimes I get called up to this. It's a legislative committee, and they tell us what they do or don't like about, usually what they don't like about a rule that we passed. And then if we don't change it, they recommend that it be sunset at the next session. This is a similar committee, but it actually would do more than just review our rules. And this actually, we're subject to it also. So right now, the committees look at our rules. They say, we don't like it. We want it to be sunset, or if you don't change it, we're going to recommend it be sunset. Now they could actually, this group could call up Deputy Superintendent Jones and say, we don't like how your board spent this money to go on a conference, or that superintendent used this money for a subscription. They could also, and if you, the other thing that's different about this one, I noticed that it's going to be staffed not only by the ledge staff, but also the ledge auditors, whereas their Administrative Rules Committee is currently staffed by kind of their policy and legal people. This new committee would be the policy legal people as well as their auditors. And so I think it serves as almost more of an auditing function, and they would make recommendations to the legislature for changes to statute, sunsetting administrative rules. You can see 190, 191. Anyway.
Okay, I've got heaps of questions and I've got some order going. So Board Member Hanson.
I've talked to a lot of people about this bill. As far as I can tell, it is not a good bill. I don't like this bill. It has oversight. This committee is going to have oversight over, as he described it, Representative Stratton, over anybody that gets state money. So they can come in to community councils, look what they do and change what they do. They can do county, city government. They can do local school districts, school boards. They can do anybody that receives state money. They'll be able to come in and veto what they did and say, we don't like this. And so I'm going to make a motion that we take an oppose on this bill, and then maybe we can continue discussion.
I second.
Okay, second, the motion is to oppose this bill. Is there any further discussion to that motion? Okay, so we'll continue with the list. I've got Board Member Lear.
And my concern, and this is to Joel's question earlier, it also says that any employee of any of those entities could be subpoenaed, could be investigated. So we now have a third district court opinion that says that board members are all employees of this board. So we could be investigated, Angie could be investigated, a secretary could be investigated, an auditor could be investigated. And I think this is incredible overreach for, and usually anti-big government legislative leadership. And I'm very troubled by that. And I think that, I also think that it's not recognizing that the State Board of Education is an independent constitutional entity. And another branch of government is now going to investigate and subpoena our employees.
Board Member Reby?
As I was listening to Representative Stratton talk about this, some of the questions were similar to that. It now takes away all of our elected positions and puts them back into this one committee. And that's very troubling to many people. And as I've spoken to many people, there is a lot of opposition to this.
Okay. Board Member Lisa Cummins?
Board members, Reby and Lear just basically stated what I was going to say. This is could be very dangerous in the wrong hands, and I am not for it at all.
Vice Chair Ellis?
Here's my struggle, and I'm not saying that this bill is written in a manner that I haven't had a chance to even read the whole bill, so I'm not trying to speak for or against the bill, but I struggle with the structure that our state has set up, simply because a government system functions on a set of checks and balances. And because of fear when our state grows granted statehood of the predominant religion indoctrinating the kids, our structure was set up where the education system is outside of that system of checks and balances. And so I've struggled for a long time with that concept, because I am a firm believer in the system of checks and balances. And so the only real oversight this body has right now is that when we create a rule, it is sent to the Administrative Rules Committee. There's not an executive branch that has veto power over our rules. And so there is a process in place, but I do struggle. So I don't want to completely say we hate this idea and we think that we stand independent of any types of checks and balances, because I think that that is very important. And I don't feel like the Administrative Rules Committee is an adequate function of that intended founding concept of the founding fathers for a system of checks and balances. So I don't feel comfortable saying anything in particular about this bill, but because I do struggle that we don't have a good system of checks and balances over education in this state, in my opinion.
Okay. Board Member Lisa Cummins?
I am going to respectfully tilt the conversation a little bit away from what Vice Chair Ellis said. For a legislative body who has no checks and balances of themselves, and there's even discussion that even the executive branch doesn't have a checks and balance, when it comes to legal authority, attorney-client privilege. I think we're dysfunctional as a government as a whole. Possibly I could say that on a Utah state base, but I think for someone to come into a local community council and say your money is being spent, I think that's a local community decision, and I would maybe even just go as high as the district to make that decision and not the state. I just want to be careful that too much power gets into the wrong hands at any given time, whoever it is. I mean, it's just not right, and there does need to be a balance. And sometimes we don't want to be so over heavy-handed on one issue.
I'd like to ask a question. Angie, under this statute, what authority does this have? Because they talk about checking or doing something, but what authority do they have the right to overturn as a committee a specific decision, or is it just that they would point out something that they don't like?
So if you look on the language here, I mean, they wouldn't be able to unilaterally as a committee repeal or sunset a policy or rule, you can see that they actually would have to recommend the administrative rule for repeal, and that would happen through the legislative process. Oh, it's right here. Well, actually, it says to the governor for review. But see, and so is ours, I apologize. 210, it's right there, 210 through 212. So make a recommendation to the administrative rules to sunset the rule. The other thing, it shows that they could refer a person to the applicable county attorney for possible prosecution. So essentially, I mean, I can give you the practical pressure. So there have been times when we have actually been called before the Administrative Rules Committee on a rule, and we have amended our rule based on the feedback of the committee, because there was a potential that they were going to sunset the rule. That has happened before. I could see, even though legally it doesn't say, well, if this group calls Superintendent Dixon and Chair Huntsman up to talk about a rule, that they actually have the authority to direct that, oftentimes that pressure does create action. And it does influence bodies like the State Board of Education to make change. And that's part of the process, I think. Because if you look, I don't think the Administrative Rules Committee sunsets, I mean, very rarely, maybe one rule a year, and usually 0 rules a year, but they influence quite a few rules through their meeting process. And I think that's what this group would also do, is they influence behavior, financial practices, policies in an informal way, because they do have this formal stick at the end, which is to repeal a rule, to send somebody to be referred to a county attorney. And they also have, they'll make recommendations to the legislature about the power of the purse, right? How much money should go to certain things.
Vice Chair Ellis?
Thank you for this. I just wanted to make the point that, yes, the governor can veto and it can be overridden by the legislature, but there is a process in place. So it takes a 2/3 majority. So it's not just that they can sit there willy-nilly. There is a system of checks and balances. And I am not speaking specifically to this bill. This was just barely put in board docs. I have not had an adequate time to review it and say yay or nay, I'm in support or not in support. So I'm just speaking in general terms. So I don't want anyone to misconstrue my statements as in particular to this bill, because there's a lot of things that have been brought out just now that I would be concerned about. I feel like I need more time before I take a position, yay or nay, on this to review it. So I will abstain from that vote because I feel like I need to read it. I need to read the whole thing and not just say yes or no based on.
Board Member Hanson?
So one of my concerns about this is not just for us, but it's for all those LEAs, all those charter schools, all of the local school boards, all of those school community councils that are going to be subject to this. And so they're part of our responsibility, and I think that we need to look out for them as well, and that's one of the reasons I'm opposed.
Board Member
I
Lear?
move that we move on to the next bill, and I'd like to come back to this potentially at the end of our discussion.
There's a motion.
Can we just,
You could move to postpone, or
that would be good. And postpone until we talk about other bills and perhaps have other board members come to our fold.
okay. So the motion is to postpone. Is that a debatable motion?
She's coming.
Oh, second. Is there a second for that?
We already have a motion on the floor that's been second to,
Correct.
we can
And
override
so-
that motion?
So this motion is in regard to the motion that's on the table, and so Board Member Lear put a motion to postpone that motion. And so
Just say.
was there a second on the motion to postpone? Okay, and then is there any discussion to that motion?
Just a comment that this is going to be heard at 2 o'clock.
So,
Okay. Sorry, then all in favor of postponing that motion for a few minutes? All in favor? Any opposed?
No.
Okay. That's Laura. Is that Laura?
Yes.
Okay. So that passes to postpone, so we can, and there's two. Okay. And just for point of process, what is the process of coming back to a motion, Lorraine, if you could help us? So if somebody wants to bring that motion back up, how does that, it's just a motion to address that? Okay, so, and that can take place at any time in the meeting, so if something else. Okay. Okay, so if you want to move on to the next piece of legislation, Angie.
Yes, I'd be happy to. And one point of clarification that I know we're going to move back to that, but I just wanted to make it known to you that your administrative rules, all of them are subject to legislative approval every year. So there's a bill actually every year that essentially makes all of our rules have effect. If they don't pass that bill, then our rules sunset at the end of the year. Okay, so while you're all thinking, or as we're postponing the discussion of HB 175, I'll quickly review HB 132 and remind you that one of the items listed on staff's recommendations or bills that we'd be working on proactively was the update to HB 239, so it's this HB 132. The content of the bill currently addresses or explicitly answers the question of what school resource officers can do. I think one of the biggest confusions in the education community after HB 239 passed last year was because school resource officers are technically law enforcement, whether or not school officials could refer or could engage and work with school resource officers in schools. So I think Representative Snow has created this new language, which primarily starts on line 74, to explain that school resource officers, even though there's some language above that says school officials may not refer students to law enforcement or to the courts for certain Class C misdemeanors, infractions, truancy issues such as that school resource officers can be involved and worked with through those issues. So you can see here that the reasonable searches, transporting a minor, consulting with school administration, investigating possible offenses, protecting property, and protecting students when there's fights or other things going on. So that's the current version of 132. Part of the reason why we wanted to talk to you about 132 today is part of the motion when this was presented to the board back in November about staff working with Representative Snow on his bill. Board Member Lear said, please work with LEA officials or people in the school districts and charter schools who actually are experiencing problems with HB 239 and get recommendations from them. So I wanted to let you know that we have actually, there's a group of attorneys that met together and worked through some potential language to be amended into Representative Snow's bill. And the attorneys have reviewed that language with superintendents, student advocacy, what are they called? Student services specialists, thank you. And the language is right here. If you look up on your screen, what it would allow is if you remember, prior to HB 239, if a student had truant, is a habitual truant, or maybe a Class C misdemeanor like smoking on school grounds, an administrator could refer them on to court or detention. HB 239 changed that and said that now, and that the current state of the law is that the LEAs may not refer and this is all in the current bill right here. If an alleged class C misdemeanor, an infraction or status offense on school property truancy, the minor may not be referred to law enforcement for those types. So the question is, and what the attorneys group had recommended was kind of a middle ground or bridge. I like how Deputy Superintendent Norman calls it more of a bridge of saying that, yes, they cannot refer them on right away, but if they have tried one or two of these alternate or evidence-based interventions, and either it didn't work for the student or the student failed to engage in those interventions, then, except for truancy, that they could refer a minor to court for Class C misdemeanor infraction or status offenses committed on school property. And so this is the language that they have recommended. I know we have heard, because Deputy Superintendent Norman participates on the JJOC's executive committee, that they've also heard this proposal for amendment. And I just wanted her to share with you the kind of the JJS's perspective on this amendment so that you hear both sides of maybe why the amendment would be a good thing. That's kind of, in a sense, it gives kind of that stick at the end and allows them to have a transition to this new norm. But I think Deputy Superintendent Norman can explain what maybe the cons are to that policy.
I love it that I get to explain it while you're actively reading the other one, so I know you guys can multitask, so thank you. The pros and cons. There's part of it, the reason why I call it a bridge instead of a middle ground is it really does seem like there's a great divide between the two. And middle ground assumes that we're all on the same playing field and we can meet somewhere in the middle. But right now there seems to be a divide in what can happen. And so the bridge was more apt to be able to describe that. So our LEAs are asking for some form of, at the end, being able to refer onto law enforcement for these types of offenses, these Class C misdemeanors and minor infractions. In talking to JJS and working with them, there's not the habit of thought in mind yet and action that our schools really have right now in knowing what they can and cannot do. So for example, in the past, they knew that if a minor was caught and they were smoking, they knew exactly what they could do, and now they don't know what they can do. So the support services that they can call and activate and get that help. So if a student is truant, who can they call? What can they do? And they have more support services on the front end instead of having to refer that child to the juvenile court system and possibly having that child for a truancy. So let's say the student's truant and they're referred on to juvenile court. That means a student is possibly now in the, is now in the legal or law, or I'm sorry, has a record because they go into the court system, possibly going to detention, possibly going on to jail. So that means that we may lock a student up for having not gone to school. So we really have to decide, is that the overall purpose of our school system, or, and as we're going to talk about it, is whose responsibility is truancy. So in talking about that is we have compulsory education and we have the responsibility of the parent. Then what is our responsibility at USBE and what is the responsibility of the LEA? And we have conflicting guidelines when it comes to that. And Brian Quisenberry's actually looked into that as to some of the things that have to happen in order to kind of bring this all together and deciding, you know, what is truancy? We have all kinds of definitions out in the schools. We have right now our schools that are saying we have more students truant, but when we looked into their policies on truancy, some were counting it as 5 days being absent, confusing truancy with chronic absenteeism or habitual truancy. So there's a confusion out there even with our rule and statute, and then what the LEAs are putting into their policies. So if we could have some clarification on that, we'd be able to identify where the most support is needed. So right now, because there's not that action, that habit of action, our schools are saying, what do we do? And that's why they're asking by saying, well, if we can try 2 of these interventions, can we then, and they don't work, can we take them on to law enforcement? Juvenile justice is saying, what's law enforcement going to do that you couldn't do at your school besides give them a record and a fine? at schools, you can also give them a citation. You can also access all of these support services. There's not something that you can do other than locking them up that cannot be done now currently through the new HB 239 that couldn't be done through the legal system. So on that's kind of the discussion between what our LEAs are asking and then kind of trying to represent, I hope to the best of my ability, what JJS was asking as well. So they would really like to have that conversation here with our Board of Education as to what you think about that, and maybe with Brian kind of trying to clarify first what that confusion really is.
Okay, Board Member Hanson.
I move that we bring the discussion of HB 175 back to the board.
So we have a motion. So that motion would take, okay, you second. So the motion is to bring the motion regarding HB 175 back before the board. Is there any discussion to that motion? Yes, Vice Chair Ellis.
Thank you, and thank you for giving me a minute to read through the bill. I see things that I am concerned about.
Can I interrupt just one second?
Yes.
So the motion is to bring it back.
Okay,
So, and then we can have the motion and then you can
that's
discuss.
fine,
Is that
thank you.
okay?
I can wait, but I do think it's okay to bring it back, but I would like to apologize to Patty for that in the middle of her
Okay.
discussion.
Sorry.
That's the way it is.
Okay. All right. So is there any discussion to the motion to bring back that bill? Okay. All in favor?
Aye.
Any
Aye.
opposed? Okay, that motion passes. So now we have before us again the motion which was to oppose HB 175 Oversight Committee creation. Is there any discussion to that motion, further discussion? So Vice Chair Ellis, thank you for allowing me to interrupt.
Oh, you're fine. I appreciate the clarity, so thank you. I do see things that I think are concerning this bill. However, I still am not willing to take a position for or against. One of the things that we talked about last session was that the legislators remember the oppositions much more than the things that we've worked with them. I happen to cover Representative Stratton's area, and I think it would be much more effective to reach out and talk to him. This is just going through one committee. It doesn't mean that it's at the floor for a final vote, and I think a more preferable approach would be to sit down and have a meeting with him than to take a motion of opposition. So I will not be joining in that effort, but thank you.
Board Member Cannon?
Well, just as I have looked through it rather briefly, it seems to me like it's creating some kind of a super legislative committee. I wonder if there are some constitutional issues with this as well, and it seems to me like it could be very invasive of the rights of privacy of individuals. I think the state board is a constitutionally based organization, and really what gives them the right. So I would speak in favor of opposition.
Board Member Bolter?
I too feel the same way as Board Member Ellis. I haven't studied this bill enough to feel comfortable enough to take a position one way or the other, nor have I been able to speak with Representative Stratton as to the intent and an explanation. So I think I'm just going to abstain from the vote. I just don't know. I just don't have enough information on this.
And I just want to add that, as we talk about opposition to a bill, we are currently, this motion would oppose what is currently written in this piece of legislation. We're not opposing a legislator. We're not opposing his concept or any of that. We are currently, this motion is to say that we don't support the wording that is in this current legislation. So I just wanted to create that clarification that there's nothing personal meant to be towards any legislator, and the conversations are always open for our board to have those conversations with legislators. So
Is there a motion on the table?
yes, there is a motion on the
Can I
table.
speak to the motion?
Okay, Superintendent Dixon?
Just, it sounds like, in speaking to the motion, several of you feel like you need more clarification, and we could certainly reach out to Representative Stratton and have him come and meet with you next Thursday, where he could explain, you could converse, and it still doesn't prevent you from taking action, correct, at that time? Is that, you could take action at that meeting. Okay, so just speaking to some who have concerns that they aren't understanding it.
Okay. Then if, oh, go
I
ahead,
call a
board member.
question?
Yeah. So the question has been called, and that's non-debatable. All in favor of calling the question?
Aye.
Any opposed? Okay, so the motion on the table is to oppose HB 175 as currently written, Oversight Committee creation. All in favor?
Aye.
Aye.
Any opposed? Okay. Okay. Who abstained then from that? Okay.
4, 6, 7, and Laura.
And Laura?
Yeah.
And I'm an
Yeah.
aye.
Yes.
She's on the phone.
Yeah.
She did. She said it. We heard her.
Mhm.
She voted for opposition.
Yes.
Yeah.
Yes.
So that's 8, isn't it?
Yes. So that motion passes. And did you get everything you needed, Lorraine? Okay,
Thank you.
great.
Go tell him, Angie.
Okay. We are past our lunch time to break for lunch. Is there anything else that board members wanted to bring up on this legislative topic or anything that's pending? Okay. Thank you very much for your help with that. And yes, board member Beebe.
This is a little bit off the topic that we were just talking about, but on our tracking sheet, is there a possibility that we could have a list of organizations that have opposed things, or is that something that we generally don't do? Because as a representative body, and we work with so many other representative bodies that we work with, it would be nice to know where other people stood on this. Is that something that could be a possibility? Or?
Anything's a possibility. If that's what the board would like, we'd be happy to do that. I know that historically, I'll just tell you that that was once a practice, and then a former board did not want that. I guess we could go back to doing that, and there's 2 ways of doing it. We could have our tracking sheet separate and then have another tracking sheet that shows positions that are taken by everybody else, or combine them. But yeah, of course, anything is possible.
Can I follow up?
Yes.
And as I work with other agencies, I'd like to know where they stand so that if I need to reach out to them or I can understand the unintended consequences that I'm not seeing, I think it would be beneficial for me to have where people stand so I can either understand it better myself or reach out to them and help them have me understand it better. Thank you.
Yes, go ahead, Angie.
If that is the will of the board, if you don't mind, if I kind of ask, just because it's something we don't currently do with staff, but ask those entities if they would like us to include it, to then make them be the proactive ones to send us their positions. We could have those go to Mark Peterson, for example, to be compiled versus our staff calling everybody, and it's only.
Board member Hanson.
I just wonder if it would be a little easier for our staff and you guys to help. But Ben Horsley already does this for Granite School District. You just have to email him and ask to be on the list, and he sends it to you weekly, and it has everybody's positions on it. And so that might be easier than our staff trying to redo it all the time. But that's just my thought.
Thank you, Linda.
Yeah, I would suggest that be the course, that if board members wanted to have that information, they could email someone that's already doing it instead of adding extra responsibilities.
Okay, thank you. Then we will break for lunch, and then we'll come back here for our executive session. And so do we take that motion now? Okay, so if we could be back here in the next 20 minutes.